December 18th, 2015, defendant Michael Patrick McCarthy was indicted for first-degree murder of Bella Bond. On June 25th, 2017, after 3.5 days of deliberations, the jury returned a verdict of murder in the second degree. On June 28th, 2017, defendant was sentenced to life in prison with eligibility for parole in 20 years. On June 25th, 2015, Bonnie Flynn was walking her dog on Deer Island in Winthrop when a plastic bag on the beach caught her attention. Upon cutting the bag open with a seashell, Miss Flynn saw that the bag appeared to contain a child's remains. The medical examiner could not testify as to the amount of time the child had been deceased, but estimated a range of at least 1 week and easily a month, possibly more. The discovery prompted police to embark on a nationwide search for the identity of the child and to enlist the assistance of the National Center for Missing and Exploited Children, which created a composite forensic photograph of the toddler from her remains. A press release with the computer-generated image of the child was sent to the media and subsequently published on the news, Facebook, and billboards all over Boston. Almost 3 months later, on September 17th, Michael Sprinsky, an acquaintance of Rochelle Bond and a childhood friend of defendants, reported to a probation officer in the Roxbury District Court that he had information concerning the child, who he identified as Bella Bond, the 2-year-old daughter of Miss Bond. Mr. Sprinsky had a lengthy criminal record and a long-standing and debilitating addiction to heroin, prescription drugs, and alcohol that had resulted in his involuntary commitment for substance abuse treatment in the spring of 2015, the last time he had seen Bella, and 3 or 4 1 to 2 week hospitalizations for substance abuse over the course of the summer of 2015. When the state police interviewed Mr. Sprinsky later that day, he explained that defendant had checked himself into the Boston Medical Center 2 days earlier for treatment of an abscess. Later that morning, Mr. Sprinsky, who had spent the previous night with defendant and Miss Bond, met Miss Bond on the street near the hospital, and she tearfully told him that defendant had killed Bella. Mr. Sprinsky testified that Miss Bond's tears, quote, didn't seem real to him, and that she didn't seem truly upset. During his interview, Mr. Sprinsky provided police with Miss Bond's address, 115 Maxwell Street, Dorchester, Massachusetts, and with a text message exchange between defendant and himself in which Mr. Sprinsky accused defendant of killing Bella. McCarthy responded that Miss Bond had told him Bella had been taken by DSS. Meanwhile, following her explosive confession to Mr. Sprinsky, Miss Bond reached out to Joseph Amoroso, Bella's biological father, who had recently come to Boston from Florida to see Bella. Miss Bond and Mr. Amoroso spent the rest of the day and night of September 16th together, and Miss Bond explained to Mr. Amoroso that Bella was in a safe place. On September 17th, after explaining that she wanted to shower and pick up some items, Miss Bond returned to 115 Maxwell Street. By this time, Mr. Sprinsky had provided the police with Miss Bond's address, and when Miss Bond realized the police had arrived at 115 Maxwell Street, she jumped out of the bathroom window and ran away. Later that day, Miss Bond finally admitted to Mr. Amoroso that Bella was dead and claimed that defendant had killed her. Mr. Amoroso's emotional outburst in response to this news prompted Miss Bond to punch him in the head and tell him to quote-unquote shut the fuck up before he got her arrested. Miss Bond also explained to Mr. Amoroso that Bella had been acting like a bitch on the night that she was killed. Although at this point, Miss Bond knew the police were looking for her, she did not turn herself in or call the police. Instead, she and Mr. Amoroso used heroin together. They then went to Mr. Amoroso's parents' house in Lynn, Massachusetts, where they spent the night. The following morning, on September 18th, state police arrived in Lynn, Massachusetts, after tracking Miss Bond by her cellular phone's location. During Miss Bond's interview with the state police later that morning, she claimed that defendant had killed Bella on May 27th. Miss Bond claimed he placed her body in the refrigerator, transported the body in the trunk of his vehicle in a duffel bag in which he had placed weights, and then dumped Bella's body into the water. Miss Bond also claimed that right after he killed her, defendant had told her that Bella was a demon and it was her time to die. In her interview with the police on September 18th, Miss Bond explained that she never saw defendant punch Bella, but assumed he had done so. Miss Bond claimed she had not previously reported Bella's murder because defendant had prevented her from leaving the apartment and kept her sedated for the past 3 months by forcefully injecting her in the neck with heroin. Despite the fact that Miss Bond's parental rights to her 2 older children had been terminated on the basis of allegations of neglect and the risk of physical abuse, and 2 separate investigations into Bella's care resulted in findings of her neglect, Miss Bond was not even considered a suspect in Bella's death. Nor did Miss Bond's extensive criminal history of drug offenses and prostitution and her long-term abuse of heroin, crack cocaine, and prescription drugs raise any red flags as to whether Miss Bond may have been involved in Bella's death. Instead, the Commonwealth relied entirely on Miss Bond's version of events in its rush to judgment on the day of her arrest to charge defendant with Bella's murder, and to charge her only with accessory after the fact. Miss Bond was later indicted as an accessory after the fact and for larceny over $250 for her continued collection of transitional aid to families with dependent children benefits after Bella's death. Miss Bond entered into a plea agreement in which the Commonwealth agreed to recommend a sentence of time served on the charge of accessory after the fact, and a sentence of 2 years probation on the charge of larceny over $250 in exchange for her testimony against defendant. On July 12th, shortly after the verdict was returned against defendant, this sentence was imposed, and Miss Bond was released from custody just 2 days later. Defendant was eventually located at Beth Israel Hospital on September 18th, where he was scheduled to undergo surgery for an abscess. While defendant suffering from uncontrolled pain awaited surgery, Trooper Joel Balducci, along with 3 other officers, conducted an interview in his hospital room. Defendant told the police that he had been staying at 115 Maxwell Street with Rochelle Bond for approximately 6 months prior to his hospitalization, and intermittently in Quincy in his father's plumbing shop. He explained that Miss Bond's daughter, Bella, had also lived there with them until a day when he came home and Miss Bond told him that Bella had been taken by DSS because of a complaint that Miss Bond had spanked Bella. Defendant was aware that DSS had taken Miss Bond's 2 older children. In response to his statements, Trooper Balducci told defendant that Miss Bond had told them what had happened to Bella, and he accused defendant of lying to cover up his involvement in Bella's death. When Trooper Balducci asked him how Bella had been killed, defendant responded that to his knowledge, Bella was in DCF custody and not dead. At that time, defendant was then placed under arrest for murder. The Commonwealth's case depended entirely on the testimony of Rochelle Bond. Without her testimony, there was no case against defendant. There was absolutely no forensic or scientific evidence that linked defendant to Bella's death, nor was there any other witness who linked defendant to the crime. Miss Bond testified that she saw defendant strike and kill Bella on some unidentified night in June of 2015. There is no corroboration of this testimony, but much to show it is untrue. She testified that defendant choked her, knocked her unconscious, and threatened to kill her if she told anyone. There is no corroboration of this testimony, but much to show that it is untrue. She told police that she saw defendant put Bella's body in the refrigerator, but then testified that she never saw this happen. While she initially told police that defendant forced her to accompany him to the reserve channel in South Boston, where he made her help him dump Bella's body into the water in a duffel bag with weights, she later testified that she was unconscious the entire time. Miss Bond told police that defendant had forcibly sedated her with drugs and held her hostage in her own apartment for months in order to prevent her from reporting Bella's death. But at trial, she testified that this was untrue. She admitted to leaving the apartment freely, having regular access to a phone, and using drugs voluntarily. She told the police that defendant had said to her Bella was a demon and that it was her time to die immediately after he killed her. Yet, at trial, she testified that defendant had just sat there, doing and saying nothing while she performed CPR. In short, Rochelle's bond testimony was such that no rational trier of fact could have found beyond a reasonable doubt that defendant had murdered Bella. A conviction that rests on the testimony so flawed, so unworthy of belief, so full of holes, so contradicted by other evidence, and so motivated by Miss Bond's desire to escape her own responsibility, violates the Due Process Clause of the United States Constitution. So when was Bella Bond killed? When Miss Bond first told the police on September 18th that defendant had killed Bella, she claimed that the murder took place on May 27, 2015, 2 days before defendant's birthday. But when she testified at defendant's trial, she professed uncertainty and estimated Bella's time of death as sometime in early June. She changed her story because on June 1st, she had sent a text to defendant saying, quote unquote, Bella sends her love. She also changed her story because on May 27th, defendant's car was getting repaired and could not have been used, as Miss Bond claimed, to transport Bella's body to the reserve channel in South Boston. She unconvincingly explained her inability to determine the exact date defendant killed Bella because she was a quote unquote stay-at-home mom for whom every day is the same, even the day on which she allegedly saw her child being murdered. From day one, Miss Bond's testimony as to when Bella died was untrue, nor was there any other evidence of when Bella died. The medical examiner testified that there was no way to reliably determine the length of time Bella's body had been in Boston Harbor before it was discovered on June 25, 2015. And the neighbors of 115 Maxwell Street apartment where Bella lived with Miss Bond and defendant could only say that they stopped seeing Bella sometime between February and June. Not only did the inability of Miss Bond to accurately place the time of Bella's death undermine her reliability as a witness, but it presented defendant with an impossible burden to establish an alibi. So when did Bella Bond die? Miss Bond testified that defendant had gone into Bella's room to put her to bed because Bella was being difficult about quieting down and going to sleep. But she testified that she became suspicious after a few minutes because Bella had finally quieted down. Why would the fact that Bella quieted down at a time where she was supposed to be sleeping rouse Miss Bond's suspicion? Miss Bond told the police on September 18th that she had then gone to Bella's room and turned on the light to see what was happening. This made no sense either. Why would she turn on the light if she was trying to get Bella to go to sleep? When confronted with this contradiction, Miss Bond walked back her testimony and claimed the light was already on when she got to the room, even though she told the police that it was off. It was at this point that Miss Bond testified that she saw defendant strike Bella so forcefully in her abdomen that she bounced on the mattress in which she was lying. But Miss Bond had told the police on September 18th, immediately after her arrest, that she never saw defendant strike Bella at all. When asked, "Did you see him do anything to her?" she responded, "I don't know what he was doing to her." By the time she testified at the trial, however, Miss Bond told the jury that she clearly remembered defendant down on one knee, striking Bella with his fist so hard that she bounced up off the mattress before flopping back down. Not only was this testimony a figment of Miss Bond's imagination, but it was flatly contradicted by the medical examiner, who testified that there was no medical evidence that what Miss Bond described had actually taken place. Thus, he testified that there was no evidence of damage to bones or organs that would be expected if Bella had suffered a massive blow to her abdomen. He also testified that there were no injuries to Bella's head and that he knew of no medical condition or injury which would have caused Bella's head to be swollen and her face to turn grayish, as Miss Bond had described. Although he opined that death may have been caused by asphyxiation or commotio cordis, he testified that Miss Bond's description as to what happened was not consistent with either cause of death. Moreover, he testified that there were no positive physical findings in his autopsy report that supported either death by asphyxiation or commotio cordis. What Miss Bond testified took place after she claimed defendant killed Bella is equally unbelievable. Thus, she testified that after she saw defendant strike Bella, she asked him, "What the fuck did you do?" To which defendant gave no response. However, she told police on September 18th that defendant had replied, "She was a demon and it was her time to die." The fact that Rochelle Bond left out her testimony, the most dramatic moment of her version of events, makes it clear how false her story was. Although Miss Bond testified that she performed CPR in Bella and that defendant just sat and watched her, she had never mentioned performing CPR in her prior statement to the police on September 18th. She also claimed not to have been able to call 911 because defendant always kept both phones in his pocket. Miss Bond also admitted that she did not call out for help from her neighbor whose apartment was separated from hers only by a wall. Why? In her trial testimony, she claimed that after she stopped doing CPR, defendant, quote-unquote, snatched me up by the neck and told me if I said anything, he would kill me. She testified that she then, quote, blacked out because defendant had choked her, and when she regained her consciousness, defendant had moved her to the couch in the living room. Shortly thereafter, Miss Bond claimed to have blacked out again, not regaining consciousness until the next night, or even 2 or 3 days later. But Miss Bond never told the police on September 18th that she had blacked out or lost consciousness at any time in the aftermath of Bella's death. She had no explanation for why she omitted this important part of her story in her initial statement to police. The real explanation is that it was all fiction. While Miss Bond's trial testimony includes significant and dramatic details which she had never mentioned in her September 18th statement, it also omitted details she had described to police on September 18th that were demonstrably untrue. Thus, she testified that in the period of time during which she was going in and out of consciousness, she did not have any idea where Bella was or might have been. She even testified that, quote-unquote, nothing had occurred that led her to speculate about where Bella might be at that time. Yet on September 18th, she told police that defendant did not dispose of Bella's body for 1 or 2 days, and that defendant, quote unquote, put her in the fucking refrigerator. He opened it up and put her in. She even specified that Bella was in a plastic bag at the time. On cross-examination, however, Miss Bond admitted that she did not witness defendant do any of this. As with so much of her story, Miss Bond's own testimony and the actual evidence contradicted what she had told police on September 18th. So how was Bella's body disposed of? Miss Bond testified that after she regained consciousness the second time, defendant took her outside and opened the door of his car for her to get in. When he did so, she claimed to have seen a green duffel bag on the back seat with an outline of Bella's thigh. She screamed, and defendant hit her on the side of her head with his hand, causing her to lose consciousness for a third time. She also claimed that he may have hit her with a mallet, a hammer, or a knife. She testified to have seen some old free weights on the back seat of the floor of his car. She admitted that she did not see defendant put the duffel bag in the car, and that when she regained consciousness, she was alone in the car, and that the green duffel bag and weights were gone. However, Miss Bond initially told police a completely different story. At that time, she had said that after Bella's body had been in the refrigerator for a couple of days, she had seen defendant put a plastic bag with Bella's body into the green duffel bag while they were in the apartment. She said that she then saw him put the duffel bag with Bella's body into the trunk of his car. She then described to police what she observed as defendant drove to a place where he put the weights into the duffel bag and took her and the duffel bag to the water, where she saw him drop the bag into the water. At the trial, Miss Bond admitted that she did not see any of this take place because she claimed to have been unconscious. Moreover, forensic investigators found no evidence that Bella's body had been in the back seat or the trunk of defendant's car. The cover-up. Miss Bond told the police on September 18th that after defendant killed Bella, he had held her hostage for months to prevent her from reporting Bella's death. She claimed that he would not let her leave the apartment until shortly before her arrest on September 18th. At trial, Miss Bond admitted that this claim was simply not true. She also told police that defendant was forcibly injecting her in the neck with heroin so that she could not leave the apartment. At trial, she admitted this was untrue as well because she was an addict and used heroin regularly. She claimed that defendant had taken her phone so that she was unable to contact anyone for help. This was demonstrably untrue. She also admitted that she lied to the police when she claimed to not have used drugs for 5 years prior to her arrest. She offered the implausible explanation to the police that she had not reported that defendant had killed Bella because he told her that he had friends who were outside the apartment with a gun and would shoot her if she called 911. Miss Bond's trial testimony and an overwhelming amount of evidence, however, showed that for the several months after she claimed defendant killed Bella, she was never held hostage. Thus, Miss Bond testified that after Bella's death, she and defendant went on living a relatively normal life as a couple during the summer. This was corroborated by text messages between them from June to September. On June 2nd, she texted defendant, "Hey, hon, get some popcorn kernels while you're there, too. They're cheap." On June 21st, Miss Bond texted defendant, "Hey, hon, don't forget about your Lyrica, just reminding you." And defendant replied, "Just tried getting it at the 24-hour Walgreens on Morrissey. They couldn't do it. Pharmacy opens at 10. On July 1st, defendant texted Miss Bond that he was helping his father out that day and he would call her soon. Miss Bond replied, "Yeah, all's well. Just keep me posted. Love you very much." On July 3rd, she texted defendant, "Hun, grab some napkins while you're out, please. We really need them. Thanks. Love you." On August 9th, Miss Bond texted defendant, "Hi, hun. Are you okay? How was church? You never answered my last text, so I hope you're all right. I love you." And defendant replied a few minutes later saying, "I'm fine. Was talking with dad. He's sending the money order in tomorrow. Heading to the clinic. We'll see you in a few. Love you guys lots." Miss Bond replied, "Thank him for me. Thank you so much too. We love you too." Throughout the summer of 2015, Miss Bond also met in private with her therapist at Nova Psychiatric in private confidential sessions. Shortly after she claimed that Bella had been killed, she told her therapist that she was stable, had no acute issues, and was better than the last time they had met. She never reported that defendant had killed her daughter, that she was being held hostage, or that she needed any help. Miss Bond admitted that she had use of a phone that was referred to as, quote, Dee's phone throughout the summer. She often used that phone to contact, quote, Julie Subs, a person with whom she bought and sold Suboxone. She also used it to stay in contact with defendant by both text and calls. Whenever she did not have her own phone to use, she regularly used her neighbors' phones to make calls. She nevertheless claimed that she was too afraid to call 911 because defendant had threatened to have people that were following her shoot her if she had tried. Throughout the summer, Miss Bond met privately with public officials and others on many occasions in connection with her applications for public benefits and housing assistance. On these occasions, she was, of course, free to report what she had claimed happened to Bella, but failed to do so. Instead, she claimed that Bella was living with her, but being taken care of by someone else at the time. Throughout the entire summer, Miss Bond covered up the disappearance of Bella by claiming to win residential, Metro Boston Housing Partnership, and residential assistance for families in need, by claiming that she was being cared for by others. She told Joe McCarthy Jr. that Bella was staying with her father. She told Michael Sprinsky, a friend of defendant with whom she'd become close, that Bella was staying with her sister. And at the beginning of September, she told Joe Amoroso, Bella's father, that Bella was spending the summer with her godparents on the Cape. The centerpiece of the Commonwealth's case against defendant from the outset was that defendant had killed Bella because he thought she was a demon. However, the overwhelming weight of the evidence demonstrates that Miss Bond attributed to defendant her own motive for having killed Bella, that she believed Bella was a demon, or that she was somehow inhabited by demons. The evidence at trial established that Miss Bond was completely delusional and that her bizarre beliefs dominated her existence. The first thing she told police during her interview on September 18th after her arrest was that she had been followed by a huge shadow throughout her life. In June 2015, she told her therapist that her mother was a Satanist, and in March 2015, she told a friend that her father was a leader of demonic people. In the journal that Miss Bond kept during summer of 2015, she wrote, and I quote, "How come so many children go missing a year? At least 1 million children go missing in the U.S. alone, and no one seems to know where they've gone. That's because leaders of every country get together and torture and rape and kill these innocent children every year just so they can drink their blood and eat their flesh so that evil reptilian demons can have a moment's sanity." 3 months before Bella's death in March of 2015, Miss Bond told Nicole Marquise, a woman she had met in her therapist's office, that her parents were demons and that when she was little, her parents would try to pull her soul out of her body. Miss Bond also claimed that demons were inhabiting Bella in order to get to her. Miss Marquise described how Miss Bond seemed to believe that another person sitting across from her in the train station was a demon and following her. According to Miss Marquise, Miss Bond engaged in a one-sided conversation with this person, accusing her of being, quote unquote, one of them. Miss Bond may have been motivated to kill Bella by her own delusions and beliefs, which she attributed to defendant. While proof of motive is not an element of the crime of murder, Miss Bond's belief that Bella was inhabited by demons at the very least raised a reasonable doubt as to defendant's guilt, which rational jurors could not have ignored. Miss Bond's parental rights had been terminated with respect to her two older children based on findings by the Department of Children and Families of neglect and a risk of physical abuse. Miss Bond's drug use and the danger it posed to her children also resulted in DCF findings of neglect of Bella in 2012 and 2013. Clearly, Miss Bond, who was the main caretaker of Bella, may have been responsible for the bruises on Bella's body, which were similar to the bruises documented by DCF in its investigation of one of Miss Bond's older children, and which the medical examiner testified were not consistent with what Miss Bond claimed to have seen defendant do. Miss Bond's delusional belief that Bella was inhabited by demons who were trying to get at Miss Bond provided her with a motive for killing her. Miss Bond's lack of credibility with respect to and how Bella died, her body was disposed of, and how she covered up her disappearance for months bolstered defendant's claim that she alone was responsible for Bella's death. Furthermore, the trial judge excluded all journal entries related to her bizarre childhood memories, as well as those discussing her ability to successfully defend herself and others. Miss Bond's statement to her clinician and her journal entries discussing bizarre childhood memories should have been admitted as evidence of Miss Bond's inability to separate reality from fantasy at the time she claimed defendant killed Bella. Whether these memories were based on true events was irrelevant, since the key issue was whether Miss Bond believed them to be true at the time she wrote them in 2015. Mental health records, and other statements going to a key witness's credibility should be admitted if they are relevant to the witness's credibility at the time of the event. Miss Bond's statement to her clinician a mere 3 months before Bella's death that her mother had killed Miss Bond's brother was relevant to Miss Bond's ability to perceive accurately and recount how Bella had died. Even if upon questioning Miss Bond had claimed that her statement referred to her mother's miscarriage as the Commonwealth intimated, the fact that a miscarriage caused Miss Bond to accuse her mother of murder went directly to the credibility of Miss Bond's claim that defendant had killed Bella. Although the journal entries discussed memories from years past, they were not too remote in time because they were written in 2015 and were therefore evidence of Miss Bond's state of mind at the time of Bella's death. Nor would inquiry into Miss Bond's statement or her journal entries devolve into undue collateral inquiry with the potential to confuse or mislead the jury. A simple jury instruction explaining that the evidence was to be considered solely in relation to Miss Bond's state of mind at the time of Bella's death and her ability to perceive and remember events accurately would have addressed any such concern. Furthermore, Miss Bond's journal entries discussing multiple episodes of successful self-defense should have been admitted for impeachment purposes. One of the key weaknesses in the Commonwealth's case was the fact that after Miss Bond claimed defendant killed Bella, she continued to live with him for more than 3 months in apparent harmony, referring to him as her husband in her journal entries, and texting him that she loved him. Initially, Miss Bond told the police defendant had forcibly held her hostage for months to prevent her from reporting Bella's death. But when it became clear that she had never been prevented from leaving the apartment and did so almost every day, and that she had access to a telephone. Miss Bond claimed that she'd simply been too afraid of defendant to leave him or report Bella's death because, quote unquote, she was scared and, quote unquote, felt trapped, and because defendant is, quote unquote, a much bigger person and had, quote unquote, overpowered her. Defendant argued that Miss Bond's journal entries, in which she described multiple instances of successful self-defense and defense of others, which she testified were true, directly contradicted her claim that she was too afraid to attempt to escape defendant in the months after she claimed he had killed Bella. The entries recounted Miss Bond throwing a 45-pound free weight at a man's head in order to save the woman he was beating up, fighting off a pimp, escaping an attempted kidnapping and rape by a man with a knife who claimed to be a cop, fighting off a man who also had a knife, and evading a beating by 3 women with brass knuckles by throwing a 72-inch television at them. However, the trial judge excluded all reference to the journal entries on the grounds that they were not relevant because they described events too remote in time and that the incidents did not describe self-defense against romantic partners as opposed to assaultive third parties. Viewed together, Miss Bond's journal entries establish a pattern of effective self-defense and defense of others that continued up until a few months prior to Bella's death, when Miss Bond took a $180 cab ride to Gardner to physically throw her sister's boyfriend out of the house because he was drunk and aggressive. Furthermore, the credibility of Miss Bond's claim that she was quote-unquote scared was a material issue since the Commonwealth's entire case depended on the jury's acceptance of Miss Bond's incredible assertion that although defendant had killed Bella, she had been too afraid to leave him or report the murder for more than 3 months despite innumerable opportunities to do so. The exclusion of this evidence deprived defendant of his right of cross-contamination in violation of the Sixth Amendment to the United States Constitution. Specifically, the allegations concerning Miss Bond's older children included the fact that she had violently thrown one of her children to the ground while he was still in his baby carrier, slapped, bruised, and potentially dislocated the shoulder of another child, and exposed both her children to drugs. The DCF investigation involving Bella noted that Bella had also suffered a dislocated elbow under suspicious circumstances, and evidence was admitted at trial showing that Miss Bond had relapsed less than a month before Bella's death, and that Bella had sustained bruises prior to death. Nonetheless, the trial judge excluded all DCF evidence relating to Miss Bond's older children, with the exception of Miss Bond's acknowledgement on direct that her parental rights had been terminated, and the termination was based on DCF's finding of neglect and a risk of physical abuse. The Commonwealth's entire case hinged on Miss Bond's claim that defendant had killed Bella at a time when only she and defendant were present. If Bella's death was the result of foul play, they were the only 2 parties with the opportunity to commit the murder, and testimony at trial established that Miss Bond possessed a motive or intent to kill Bella. The belief that Bella was possessed by demons. Furthermore, the incidents involving Miss Bond's older children provided substantial connecting links to Bella's death, because Miss Bond admitting to abusing drugs around Bella near the time of her death, and the autopsy of Bella's body revealed unexplained bruising that had occurred pre-mortem. What is more, no one testified to ever witnessing defendant engage in any physical violence with Bella. Yet Mr. Sprinsky admitted to having witnessed Miss Bond spanking Bella, quote-unquote, hard enough to hurt her, and in a manner that was, quote-unquote, definitely not ordinary. In view of the fact that the evidence established Miss Bond had the motive or intent to kill Bella, because of her belief that Bella was possessed by demons, that she had the same opportunity to do so as defendant, and that the medical examiner was unable to establish the cause of Bella's death, it was critical that defendant be permitted to present evidence raising a reasonable doubt as to whether Miss Bond was involved in Bella's death. There was much evidence deliberately kept out of the trial and away from the public. It is no secret that Rochelle Bond lost her first two children to the state. The fact is that the courts had already deemed Bond a threat to her own children's safety. The courts terminated her parental rights not once, but twice. The DCF records were all kept out of the public eye. The judge determined that the jury could only hear the fact that Bond lost her children for the risk of abuse and neglect. Why would the judge not allow the jury to see the records? The names of her first two children were retracted for privacy purposes. Why not let the public see? What the records revealed was shocking and not in the best interest of the state regarding her mental state and dangerous parenting with all three of her children. The fact that the state had terminated Rochelle's parental rights in the past for the same behaviors she was displaying this time with Bella would indicate the state's incompetence yet again for another high-profile event regarding a child's death. The records regarding Bond's first child indicate that Bond had claimed to a DCF employee that her mother, Dee Dee, was in a cult, and Bond feared she would try to get her child if the state took custody. The state then took custody because clearly a mentally ill woman talking of cults, using drugs around, and physically abusing her child could have disastrous results. The fact is, Bond displayed essentially identical abusive and dangerous parenting while being in a delusional state of mind with her first two children that she did with Bella. The state prior had terminated her parental rights for her inadequate parenting. However, the state did not terminate her parental rights regarding Bella, even though Rochelle was displaying the same dangerous characteristics that she had with her prior children. Then Bella's body was found discarded in a bag. The state had been under severe scrutiny for multiple high-profile children's deaths in recent times leading up to the death of Bella. In 2014, a boy named Jeremiah Oliver was placed by DCF in a dangerous home. The DCF employee Sarah Vasquez tried to have Oliver removed. Since the state had deemed the home fit, they would not remove him despite Ms. Vasquez's best efforts. Similar to the upcoming Baby Doe tragedy, Jeremiah went missing. Again, like Bella, pictures of Jeremiah were circulated and viewed all over the country. Tragically, his remains were discarded and found in a bag. In fact, in August of 2015, while pictures of Baby Doe were circulating the globe, Sarah Vasquez was suing DCF, the Commonwealth of Massachusetts, among others. Just prior to that national event was another event highlighting the House of Horrors of the DCF failure in Massachusetts. The clearly mentally ill Erica Murray was allowed to care for her children despite the nature of her home being equal to that of a biohazard dump site. DCF employees entered the home with waist-high rubbish throughout the entire home. The stench of the home could be smelt from great distances. The children's appearance recorded by one DCF employee was, quote-unquote, the children looked and smelled as if they were dipped in feces. Neighbors continually called DCF. The state agency was well aware of the grave danger Erica Murray's mental illness imposed on her children. Again, the state made an error overlooking Erica's mental illness, and this mistake resulted in tragedy. 3 children were found dead in the House of Horrors in piles of rubbish. The children's remains were removed from the home. Miss Murray was arrested and charged with multiple charges. The home then had to be wrapped in a giant bubble before being demolished, as it was literally a biohazard harmful to the environment. So, understanding the conditions in Massachusetts in 2015, would it be so hard to believe the state not wanting to charge bond? If it had, then certainly the DCF records would now be evidence showing Bond's clear, consistent history of leaving drugs around her children, physically abusing her children, and overall negligent behavior while being in a dangerous delusional state of mind. Has history not proven time and time again that political figures will be reckless and cunning to protect their interests in a time of turmoil? Like DCF in Massachusetts, the medical examiner's offices rates among the worst in the nation regarding its quality of work. As you know, the medical examiner could not testify to what the cause of death was. He gave opinions only essentially based on how one could be murdered without leaving any trace of it. However, he may have and likely made more unthinkable errors other than the one he was willing to admit on the stand. It is a fact that Bella Bond had methamphetamine in her system when she was found on Deer Island. The toxicology report indicated that Bella indeed had methamphetamine in her blood. It is a fact that Rochelle Bond had a lengthy history of leaving dangerous narcotics around her children. It is a fact that Rochelle Bond was prescribed one of the most potent forms of methamphetamine on the market, Adderall, 20 milligrams instant release. She was prescribed the potent narcotics each month of 2015, including May and June, the estimated time of Bella's death. It is a fact that Bella had unidentified pink-orange fluid in her stomach when she died, which would mean consumed before death. It is a fact that the Adderall tablets Rochelle Bond were prescribed were pink-orange in color. It is a fact regarding the toxicology report. The medical examiner admitted to making an unthinkable error. He admitted to attaching information from another corpse to the back of Bella's toxicology report. The information consisted of a series of brain and brainstem injuries. The medical examiner, however, testified Bella could not have died of an overdose because her body naturally produced the methamphetamine. This rare phenomenon is possible, although he had never personally seen it before. His reasoning was he sent out Bella's organs to be tested in another lab across the state, and that lab tested them weeks later and sent the results the following month. So then could the error of recording the wrong information happen twice? It already happened once, so surely it's possible, perhaps even probable. It is likely that Rochelle Bond left her potent narcotics where Bella could find them. It is a fact that Rochelle Bond had a lengthy history of doing precisely that. If the mentally ill woman with her lengthy criminal history had found her daughter dead as a result of her negligent, abusive parenting, what do you think she would do? Call 911 and send herself to prison? Or do you think she would panic and get rid of the body? Then months later, when her lies regarding her daughter's absence caught up with her, she made up the bizarre tale she told police when they arrested her. Let's look at the plea deal between the state and Miss Bond. The deal was that Rochelle pled guilty on the charges of larceny over $250 and accessory after the fact to murder and would receive time served in exchange for her complete truthful testimony against McCarthy. When looking at the plea deal, it states that this agreement is contingent upon the truthfulness of the information Miss Bond has provided and will continue to provide law enforcement officials. How insulting to justice itself. How appalling to the integrity of the district attorney's office, as well as the court and the people. When one story changes countless times, it is clearly not truthful information. The district attorney's office knew, just like everybody else, that her story was absurd and untrue, yet they still entered a plea agreement to be used in a homicide trial where the fate of yet another life was recklessly put in the hands of Rochelle Bond by the government. When looking at the second paragraph, which states, specifically, it is my understanding that Miss Bond was present and made observations regarding the homicide of Bella Bond. It is further my understanding that Miss Bond did not directly participate in the murder, that Miss Bond neither struck her daughter nor did anything to cause her daughter's death. Finally, it is also my understanding that Miss Bond was not involved in any conspiracy to assault or kill Bella Bond, and that Miss Bond did not have any prior knowledge of the intent of any other individual to assault or kill Bella Bond. Again, highly insulting to justice itself and the integrity of law enforcement, the DA office, the court, and the people. As David Deacon would tell the jury, the judge, and the people that authorities knew Bond was more involved than she was, letting everyone on to believe. If the district attorney learns that the information or testimony which Miss Bond provides after the date of this letter is not complete and truthful, then this agreement may be considered null and void by the district attorney. Should the district attorney declare this agreement null and void because the information or testimony provided by Miss Bond is not complete and truthful, the district attorney may recommend the court to impose any lawful sentence on Miss Bond for any offense that evidence permits, including a prosecution for perjury. Was Miss Bond's testimony complete and truthful? Clearly not. Definitely not. A member of the district attorney's office who prosecuted the case acknowledged it was not complete and truthful during the trial, during his closing. This case absolutely classifies as a travesty of justice. No justice for Rochelle Bond as she is free after all this. No justice for Michael McCarthy as he is serving a life sentence for murder when it was never established where, when, why, or how Bella died and who was responsible. And most certainly, no justice for Bella, because as stated, almost nothing is known regarding the circumstances of her death. Michael McCarthy's appeal has been filed, and hopefully his case is looked at with some fresh eyes and overturned, so then perhaps this situation can be properly remedied. Prior to the trial, there are pre-trial conferences between the judge, prosecution, and defense. The prosecution and the defense each present pieces of evidence to the judge which they feel are important and relevant to illustrate to the jury a clear picture to show what transpired. The judge has the power to drastically alter how the case will be viewed by the jury. Further, a legal strategy must be developed by the defense based on the allowed evidence and the prosecution's theory of events. Regarding McCarthy's defense strategy, the prosecution was alleging that Michael McCarthy alone murdered Bella Bond. The prosecution adopted the position that Rochelle Bond did not participate in her daughter's murder, and that she was held against her will by McCarthy for months after the alleged murder, preventing her from going to authorities. Since this was the state's position, the defense formed a legal strategy to raise reasonable doubt as to McCarthy's guilt based on the prosecution's theory. As a matter of law, the defense would raise reasonable doubt as to McCarthy's guilt by disproving the state's theory. To comprehend the fast one and the state pulled to unjustly secure a wrongful conviction, you must understand the charge of murder by joint venture. Joint venture simply means multiple people participated in a murder. In a joint venture case, multiple people would have to be charged with being involved in the crime. However, there was no joint venture charge in McCarthy's case. He and he alone was charged with murder. So, as a matter of law, for a jury to convict McCarthy, they would have to determine he and he alone murdered Bella Bond and no one else was involved in the crime. Since the state charged McCarthy, and only McCarthy's defense strategy was to raise reasonable doubt as to his guilt by simply showing Rochelle Bond was more involved than she was willing to admit to. For if she was involved in this crime any more than she was willing to admit, then she may have taken part and or be responsible for her daughter's death in any way, shape, or form, then as a matter of law, McCarthy was not solely responsible for the murder as the state charged, and reasonable doubt as to his guilt established. So this was the way the entire trial was presented by the prosecution and defended by the defense. At the end of the trial, a fast one was pulled by the prosecution and the judge. McCarthy had certainly shown Bond's testimony was untruthful. The prosecution had to have known the jury could not have believed Bond's testimony for many reasons. The jury's disbelief in the one and only alleged witness's version of events was the reasonable doubt McCarthy hoped to raise. The prosecution, realizing its case had fallen apart, or perhaps it was the state's strategy all along, requested, after the defense made its closing argument, that even if Bond was involved in her daughter's murder, they could still convict McCarthy as a joint venture, even though neither of them were charged as joint venturers. The judge agreed. The state now, in its closing, backed off its entire theory, knowing no one believed it, and now adopted the defense's theory that Bond was more involved than she was willing to admit. The reasonable doubt raised by the defense of Bond's involvement was now used against him. So the jury believed the defense that Bond was involved in the crime. McCarthy and McCarthy alone was to be found guilty still. This sinister, cunning, deceptive tactic stripped McCarthy of any and all hopes of ever walking out of that courtroom. For now, the judge would tell the jury that the state doesn't have the burden of excluding the possibility that others were involved in the crime, meaning you can convict McCarthy even if others were involved. McCarthy's lawyers, as a matter of law, based its entire defense on raising reasonable doubt by showing Bond was involved. This is a perfect example of a statement with a ring of truth to it, which is, sometimes what's legal and lawful is not at all just. It is an outrage that authorities obstructed justice for Bella and recklessly abused their authority by improper use of law and abusive psychological tactics. The prosecutor himself acknowledged that the authorities' view was that Bond was not being honest. Therefore, there is no way the administration of justice could be proper, as the prosecution allowed and assisted Rochelle Bond to escape blame and accountability for her daughter's death and assist her in committing perjury. It is hard to fathom the judge and prosecutor engaged in multiple conversations in court, which they alluded to Rochelle Bond killing her own daughter, and plotted to find the right language in order to explain and instruct the jury how McCarthy could be convicted even if Bond was the killer. Authorities blindly accepted Bond's implausible, ever-changing story, full well knowing she was lying. The state offered her lies as the truth to the public, and the court when they absolutely knew her allegations were all lies. Further, authorities in their plea agreement with Bond required her to give complete and truthful information, yet the prosecutor himself acknowledged authorities knew she was lying by saying in his closing that authorities' view was that Bond was more involved than she led us on to believe she was. He cunningly suggested to the judge that Bond murdered her own daughter by saying if the jury were to conclude Rochelle Bond was the murderer, which is not a position I'm advancing, but were the jury to conclude that Bond did it, I think the jury could convict McCarthy for being somehow involved. I will ask the jury to convict him. Shockingly, Judge Janet Sanders agreed. How could this be? How can the prosecutor acknowledge his only supposed witness was untruthful and gave false information to police? And how could he tell the judge that Bond may herself be responsible for her daughter's death, yet not investigate her and allow her to commit perjury? Where is the honor, integrity, and trustworthy conduct required from both the prosecutor and the judge? How can a prosecutor acknowledge that Bond may have murdered her own daughter, yet not even consider her as a suspect and allow her to blame someone else? How can a judge allow this conduct and a malicious prosecution to take place in a court of law? Isn't all of the evidence contrary to McCarthy's guilt? The sole supposed witness giving untruthful testimony as admitted by the prosecutor himself? No known cause of death? No body ever in McCarthy's vehicle? Bond never being a hostage? How does any of this make sense? Think about it, and you be the judge.